Right. Hello, everybody. Thank you for attending. This is another important meeting for all the members of U.S. Inventor. So I know that some of you may not have been to our previous meetings. I want to first give the mission of U.S. Inventor. So the mission of U.S. Inventor is to restore to inventors and startups the rights that were intended initially that are found in the Constitution that enabled America to lead the world in innovation, rights that have been lost significantly in recent years. And of course, today, we're going to be talking about legislation, the Patent Eligibility Restoration Act, known as PERA, Patent Eligibility Restoration Act. We don't have an official position yet, but I will say this. We see it as a vehicle for getting the kinds of change we need, yet there are some serious risks that need to be really understood and mitigated. And that's the purpose of today's call, to have some professionals who deal with litigation and who are experts in the area kind of bring up what it is in this bill that should really be taken a good hard look at, that needs to be mitigated. And I want to say a couple things. One, as a disclaimer, anything you hear on this call is not to be considered legal advice, as for the same for previous calls or future calls. It's not legal advice, even if it's coming from an attorney. Just so all of you know, we have a lot of important people on the call. This is a very significant call, and glad you're attending. And the other thing is the people we have today: Robert Sachs, Rudy Fink, Rob Greenspoon, Phil Mann. I'd like each of you to introduce yourself and just say very quickly, who you are and what you do, and then we'll take the meeting from there.
Okay. Yes.
And in fact, start with Robert Sachs.
Hi. I'm a patent prosecutor. My specialty, so to speak, is software. I've been doing software patents since about 1992. So cut my teeth on 101 rejections starting back then. Did a lot of research, tracked the law for many years. Wrote after Alice came out, or after Bilski came out, started the Bilski Blog and started commentary on 101. After Alice came out, started tracking every federal district court and federal circuit decision on 101 and kept data on the rates of invalidation. Maintained a private database of every single office action issued by the USPTO starting in 2014, and analyzed those for the rates of Section 101 rejections, and published data on that, showing in both cases the rates of invalidations, the rates of 101 rejections were skyrocketing, the rates of abandonments due to 101 were skyrocketing. So I've been looking at that for a long time. I was co-chair of the IPO Section 101 committee to draft legislation, and was the primary author of that draft. And PERA actually has language lifted right from our draft. So been involved in this for quite a while. I've been thinking about it for a long time.
Right. Thank you. Rudy, tell us about yourself.
Yeah. Hi, I'm Rudy Fink. I'm an engineer turned attorney. I spent a number of years on different sides of these issues. Spent a number of years after graduation working for corporate and academic research groups, basically making patent and published patenting and publishing technology on a number of different areas. After that, I went to law school. During law school, I worked for the biggest of the big patent firms, primarily on the defense side and patent litigation. Decided I needed the court's perspective, so I then went and worked for the judiciary for a number of years as a law clerk. I was fortunate to clerk for three very wonderful and hardworking judges in the Eastern District: Judge Roy Payne, Judge Rodney Gilstrap, and then Judge Bryson at the Federal Circuit. And then after that, I've been primarily on the plaintiff side. I'm now at the Davis firm, and basically we're a smaller firm that focuses on very great capability and efficiency, which gives us a lot of flexibility in the cases we represent.
All right. Thank you. Robert, tell us about yourself.
Yeah, hi. So I'm Rob Greenspoon. I'm at Dunlap, Bennett, and Ludwig. I'm a litigator and appellate attorney. I've been a war fighter in the trenches only for one side of the issue. Ever since this patent subject matter eligibility issue really bubbled up as a litigation defense. Starting back in 2013, I was filing amicus briefs in all the appellate proceedings for the Alice case to try to convince the courts that we have a statute, we have a constitution, we have a statutory scheme where the defenses to any litigation act, to any infringement action, are written into the statute, Section 282, And guess what's not in Section 282, patent subject matter eligibility? Well, nobody listened to me at the time, so we had the Alice case, and the Supreme Court went ahead and dived in and said this is a litigation defense, and here we are. So I've been a war fighter in the trial courts and the appellate courts on this issue, mainly trying to stick up for, exclusively trying to stick up for inventor rights.
All right. Thank you, Robert. Phil, tell us about yourself.
Okay, well, thank you, Robert. My name is Philip Mann. I've got my own firm, the Mann Law Group, based here in Seattle, Washington. I have sort of a long career. I began my practice in 1983, right around the time that the Federal Circuit first came into existence. And it's been interesting over the last almost 40 years to see how the court created a very coherent and understandable body of law. And to see that over the last 20 years be more or less dismantled is a little bit disheartening. And so I've sort of seen that when the patent laws made sense, they were easy to figure out. It was easy to make predictions. It was easy to advise clients. And now it's become frankly, a mess that I don't understand. And I suspect that many others don't understand. For the last 20 years, I've been representing smaller businesses and individuals on a contingent fee basis. 20 years ago was very possible and practical to bring such cases. Today, we turn down most of the ones that are offered to us, not because we don't want to do it, it's because of the realities of Alice and other cases. Really started with the eBay case about 15 years ago, took the teeth out of the law. So this is an issue very near and dear to my heart. That's why I'm happy you have found the U.S. Inventor Group. And like most lawyers, I have some opinions on this that we'll be happy to share. I'll be happy to share as we go forward. Thank you.
Well, super. Well, thank you. And just so everybody attending knows, I don't think there is another national group in existence that entirely represents inventors and startups. But that's U.S. Inventor. That's what we do, and we've grown quite a bit, and we're making a dent, and we're making things change, and that's the purpose of course, digging into this law and seeing what needs to be improved about it to make sure that it does what needs to be done. Mm-hmm. So Ron Katznelson, you guys know Ron. Ron, I refer to Ron as the smartest guy I know. Ron obviously has a huge amount of experience in this space, and Ron, I'm going to let you take it from here.
Thank you, Randy, and thank the attorneys who joined us today in a round of efforts that U.S. Inventor is pursuing to find ways to improve this legislation, which, as Randy said, is a vehicle for improving the law in Section 101 and eligibility. And so we're concerned about various elements in this proposed bill that probably need some improvements, and clarification is in order. So for this group here, I'd like to start with one question that is more related to the purposes, and particularly the preamble. Preamble is a really important part of the bill in the sense that it actually is the act portion of legislative intent to some degree, without having to resort to legislative history, which some courts and some judges basically ignore. However, they can't ignore the language of a preamble of an act. It's in the act itself, even though it doesn't have the power of the actual statutory provision. So I'd kind of like to go across from all the members here about their view of the preamble, what's in it and what's missing from it. And then we'll see where people stand. So we'll start with that. So maybe, Rob, you can start, and then the others can take it.
Yeah, so are you speaking of the findings?
Yeah, the findings, yeah. Right. The findings typically is a preamble. It could be whereas, or the findings, or okay, recitation. Yeah, the findings in this case.
Let's do this. Let me share my screen just so everyone can see while we talk what we're speaking of. So let me. Oh, this is not working. Okay, can everybody see what I've done with screen share?
Yes.
Okay, terrific. So the findings go into for many years after the original enactment of Section 101. Basically, this is a jab at the Supreme Court. That's how I read it. This is a discussion, and I wouldn't call it dispassionate. It's a very opinionated discussion, how many judges have expressed a need for more guidance, et cetera, et cetera. You don't see this usually in statutes. So you know, kudos, Ron, you're right. This is quite an amazing, lengthy set of words. Well, the words that stuck out for me were in Section 5. I think I put it on the screen. Under this act and the amendments made by this act, the state of the law shall be as follows. A, all judicial exceptions to patent eligibility are eliminated. So I'm going to take that off the screen just because I think it can get distracting. But
that's not the case, is it?
That's the intention stated there in that part of the statute. And I have a presentation I've put together where we can walk through the actual operative language of the statute, sort of engine room or you know, boiler room where all the work is actually supposedly done. So in terms of findings, I think it's extraordinary, like you do, Ron, that Congress is trying to make sure that the courts get it right. But there is going to be some tension, which we can go over in the operative business end of the statute, where it doesn't seem like the lofty goals are being achieved. And that's my opinion. That's my point of view.
Yeah, I guess what what I meant is more of what's missing there. There's also a matter of a preamble like that has to be factually correct. When a statement said all exceptions are taken out, it's really not true. When after that there's specific exclusion. Nor is the finding explaining why certain provisions are there. It does explain why certain provisions are not there, why they're trying to take away things, and that's great. The problem is it doesn't explain why exclusion of a whole swath of subject matter, like economic, business methods, and things like that are excluded. You'd think that when you change the law from Section 101 to 1952 Act, that has no exclusion, to now identify exclusion, a very named exclusion, there will be something in the preamble that would explain the public policy for introducing those exclusions. What is the intent? What is the purpose? None of that is in the preamble. And so that's one of the things that seems to be missing and pretty much in spades. Other elements is explanation of why specific provisions on the explanation of what utility or usefulness is. What's the purpose of that? What is the problem Congress is trying to solve with now defining usefulness, when in fact the definition is none other than that which the law is already included? And the same thing for the discovery, preliminary discovery or limited discovery. So I see missing elements of explanations in the preamble. So I'd like to turn to other panelists here, maybe take on the same issue.
So I would say that the statement that all judicial exceptions to patent are eliminated is sort of true only in a very technical sense. Yes, judges cannot make more of them. If that's the intent, then it should say, no further judicial exceptions are allowed. But clearly it has codified the existing judicial exceptions. So yeah, there's no more judicial exceptions, but the ones that were judicial exceptions in name are now codified in law. I don't think that gets you anywhere. The part that I am a little bit concerned about is E, where it talks about process claims drawn solely to steps undertaken by human beings and methods of doing business, performing dance moves, offering marriage proposals, and the like shall not be eligible for patent coverage. Dance moves and marriage proposals, bizarre non sequitur references. I mean, these are not what people patent, and it's
well,
a sideshow.
And marriage proposal is excluded by printed matter doctrines in Section 102.
Regardless, I'm saying these are super tiny niche issues, and they're not the reason why we want to amend 101. And then the inclusion of methods of doing business saying not eligible, well, that sort of begs the question, whether they're eligible to begin with. And even the Supreme Court has said they are not per se ineligible. They said that in Bilski. They are not per se ineligible. So you're actually, if you say they're ineligible here, you're actually wiping out, you're creating a category where none needs to be created. So that concerns me. And the saucy or flippant, do it on a computer shall not be settled for eligibility. Nobody who is qualified to write a patent ever says, do it on a computer in a patent claim. It's this shorthand, again, that gets tossed around and creates more confusion than it should ever do. So that kind of language being encoded into the statute is just more kind of red flags, and it's distracting.
But Robert, isn't it also true that the actual exclusion with the practical element is in fact saying do it on a computer is not eligible? Because it says if you have a way to do it without a machine or manufacturer, it shouldn't be eligible. Well, that's exactly in different words saying just do it on computer is not enough.
Again, I take words seriously.
Yeah.
I take words in the statute seriously. And so shorthand references like this to people who don't understand what patent claims actually say, and for the Supreme Court to have said it that way makes it seem like, well, that's all that patent attorneys do. They just say, do it on a computer. Well, that's not what we do. That's not what anybody does. That's not anyone who knows what they're doing does. And so again, it creates a straw man that's just, it's irrelevant. As to
but even if the straw man is accepted and people understand what's behind it, it is contradictory to what the statute actually says.
No, and it's contradictory in some sense to, in fact, if you claim it as operating on a computer, then you have claimed under Appellate a particular machine. So doing it on a computer, which
Right.
Many things require computer operations, they are inherently claimed as computer operations. That it's not do it on a computer. It is what a computer does. So again, this seems to create the possibility for actually undermining the very intent of restoring the broader scope of eligibility.
Right.
So this
Anybody
could,
else?
this could be used in litigation to say, according to the congressional intent, that he's just doing it on a computer. I'm using those words, and it can just be litigated. And that's your concern.
Bingo.
Okay.
Yeah.
Anybody else have a comment on that?
Well, sure. This is Phil Mann. I guess when I read it, my take on it was more of a shot across the bow to the Supreme Court and the Federal Circuit. It was more, I came across as, look, guys, you better get your act together or Congress is going to step in. And I think that this was a demonstration of what the Congress may perceive as a problem here. So rather than looking at it as something that would be the grounds for arguments during litigation, it's not the substantive aspect of the law, it's more the findings and preamble. But I interpret it more, as I said, more of the sense of frustration on the part of Congress that the courts aren't doing their jobs, and an indication that, look, if you don't do it, we're going to do it for you. Many of these bills, as we all know, a lot of these bills get introduced and they never actually get passed. It's more done for publicity's sake, and that may be what's going on here. But I agree with Ron. It is contradictory. It says we're eliminating all these bars to patentability. Then they say, except for all these additional ones that we're now adding. So it is contradictory in that sense.
Rudy?
I was going to say, I largely agree with what everybody else is saying. I think the statements of intent at the beginning are good, but then it largely overlaps a bit with what's said below. And I think that potentially is just going to be a ground for confusion in some sense. I think that the idea of providing guidance and these sort of strong statements about, the sort of courts eliminating eligibility for patents are very helpful to guide people who are going to interpret this. But then to the extent it kind of overlaps with what's saying later, what's later in the bill, and the overlap is not clear, I think that's just going to promote essentially fights down the road. But overall, it says some, I think, things that are useful, but then other ones that as people are discussing are contradictory.
Move on.
Let's move on to the next issue then. We've got time constraints here.
I
We
had
need
a quick comment on the preamble before we move on from that.
Okay.
Actually, just to capture for the audience what we're talking about. So there's the substance of the bill, the actual law is below, and I think we're about to talk about that.
Yeah.
Right now, we're talking about the commentary of the sponsors of the bill, and I just want to highlight for those advocating for this bill and for the sponsors, Coons and Tillis, these are their words. The following inventions shall not be eligible for patent protection. And then you go down and it says a process that is substantially economic, financial, business, social, cultural, or artistic. So I take that to mean that Senator Tillis and Senator Coons do not want to issue any patents on processes that are economic, financial, business, social, cultural, or artistic. That's my take of what their intent is.
Yeah, and that seems to be some kind of concession to big tech or others, possibly Electronic Frontier Foundation and the ACLU. You know, there's lots of people who conflate or think that patents interfere with free speech, which I don't think is an issue at all, frankly, if you knew about patents. And I think that's just some kind of genuflection to that. But what it is, it turns these little categories, these little niches, these will become semi-truck sized sinkholes that any good defense attorney will be able to throw your patent into. So let me give you an example, and because these show up in the main text. So artistic, I imagine we have inventors on the line who do computer software, probably do animation software. I represented DreamWorks for many years. I did the patents that was done on Shrek for how they modeled hair, better hair than this. Well, that's clearly artistic. That's for movies. So an animation technique for rendering hair, okay, it's claimed to software, but they'll say, well, that's artistic. That's artistic. So that's not eligible. Anybody do social media? Anybody have patents related to social media? What word did I just say? Social. There you go. Defense counsel now has an argument. Oh, this is newsfeed, or this is sharing information on social networks. That is by definition a social invention. And I can string these examples along all day long, and I'm not even getting paid to do it. Imagine a good litigator could make these arguments up and down all day long.
Yeah, I mean, I think one way to think about it is, you know, if you're from the defense perspective arguing this, what in a sense process isn't economic, financial, business, social, cultural, artistic, or somewhere in that vein, you know, that basically fits, at least at some level, an argument, pretty much all of human endeavor.
That's right.
Yeah, here's a Daryl Metcalf comment. If it's valuable, it's in that list. That's
Yeah, exactly.
Yeah.
So financial, I mean, that's what we have been arguing about. So this attempts to cabin in some strange way, but it's not an exclusion. So what they say is this whole, let's jump ahead to the whole in, out, in analysis. And let's talk about that, because I think that's the core of the whole problem here.
Yeah, you mean now the exception has a safe harbor, so to speak, or at least purported safe harbor, that if computer or manufacturer is essential for the claim, then it should be a safe harbor and it should be eligible.
So
But
let's go to the text. Let's go to the text of that part. Rob, can you pull your
I'll do
screen
that.
up and show
I'll
that
do that.
text?
Go ahead, Rob.
This is
Go
the
ahead, Rob.
actual. This is the actual text of the law.
Yeah, so
not
this is
the preamble.
this first slide is just an adaptation of something I did for one of the attendees on the call today in court a couple weeks ago. Section 101 is just the front door to the patent system, and you got to get that across to anytime you're advocating here. It's just the front door. But here's a text. I've annotated this, and you can see my point of view on this. If we're going to spend cycles trying to improve the law, let's not do it in half measures or set us back actually a couple of eons. So the first subsection, I think it's been tweaked a little bit, but section A of this, what I call the business end of this enactment, is just about what it was before. And I write, so far, so good. And then the eligibility exclusions begin in subsection B. And I like how, was it Robert yeah, I think Robert, you said the in, out, in, or out, in, out. It's what I call the layers of the onion, or the wheels within the wheels. It's like you don't know where you are, and as you're descending these Dantean levels of, okay, well, the thing I just read means that my thing is out, but the thing I just read is an exception to the thing being out, so it's in. But then there's the exception to the exception, so now it's out again. So you can just lose yourself in that. So my comment is, why can't we just say what the statute's prefatory paragraph says? Why can't we just say no court shall enforce any judicial exception so as to exclude any patent claim from patent eligibility? And that's the amendment to the statute. I don't know why it can't be that simple. And if I think there's concern that 101 does work that other parts of the Patent Act don't do, we can get into that. I think the proponents of this, who are acting in good faith, think that we need something like this to prevent dance choreography or the patenting of E equals MC squared as such, because that always comes up as an example, a pure mathematical formula. But we can go into that, and other parts of the Patent Act already carry that water if we need that water carried. So here's the in, out, in, okay? The capital letters here on this row here, A, B, C, D, and E. Those are the things that are now the statutorily enacted exclusions from patentability. So in this sense, we're eliminating judicial exception. We're making them congressional exceptions if this passes. So essentially, A is mathematical formula. B is that list of things that are everything valuable these days. C is a process that is purely performed in the mind, occurs wholly in nature. D is unmodified human gene. E is unmodified natural material. You can tell that the authors of this statute were trying to simply codify the things that the Supreme Court and probably the Federal Circuit has already said, codify them so that it's no longer a separation of powers issue where there's concern that the judiciary is stepping in and doing policy making where it should not. And then we don't have to go into my annotations on the side here, but these are the things that are out, A through E, capital A through capital E, and now we get into the little I and the little double I. So so the little b double I, the process described in clause I, shall not be excluded from eligibility for a patent if the process cannot be practically performed without the use of a machine or manufacturer. How many negatives are there?
Next slide. Go to the next slide, Rob.
Right. Here's the next slide. And this tells you about the things that are brought back into patenting for the pharma industry. And those are isolated, purified things.
Go back. I missed the go back to the language for the the savings clause.
Okay, the savings clause is actually on the middle slide.
Oh, there it is. Yeah, right.
Okay.
So let me say something first, Rob, real quick. BI, the preface to this is it is ineligible if a process is substantially economic, financial. So this makes it ineligible across the board. Everything is ineligible. And
Correct.
then II saves it. So now, just
Right, so
Well,
Yeah, so that's
it
what I
doesn't
said.
save it all. It doesn't save it all. It has an exception to the exception. It's
Right.
got a safe harbor for certain things.
Right. So that's this. It's in, it's eligible, it's out, it's ineligible, and then it's back in again. Now, most people don't think this way. This is not how humans generally think. It's out, it's in, it's out, it's back and forth. And then the two is a double negative. Shall not be excluded if it cannot without. Only really convoluted lawyers think this way. This is not an easy thing to parse. I'm a trained logician and I have problems with it.
Yeah,
But the real thing is it's as we talked about before, what constitute, and Rob's comment is just bingo. 10 years of court decisions to interpret it substantially. What does that mean? Econ, finance, business, art. So after Alice, you had 3 more or less: mathematical formulas, fundamental economic activity, methods of organizing human behavior, and abstract ideas. We had 4. Now we got, and we know what happened after Alice. We know what happened after Alice. I called it Alice Storm. Okay, the rates of invalidations went up. My last paper in 2019 said there had been it was a 68%, 62% likelihood of a Section 101 or other similar motion being granted. So the defendants had the odds were in their favor to invalidate. There had been over 700 patents invalidated in 5 years, and the invalidation rate inside the PTO skyrocketed. And that was just with a handful. Now we got a whole bunch more. Now we got a whole bunch more with these. Okay,
Yeah.
so that's the problem.
I guess I was just going to say briefly in the context here, I think, since the hearts are in the right place to try and make these things clear, but the problem, at least I would see with this BI exception, sort of what does it fall in and then does it fall out, is that, we're talking again, I think it was Rob had this good idea of a door, but, these are areas that you can't have a patent in no matter what, right? So no matter how good your mathematical formula is, if it solves the, world's problems, it's not patentable. Or that if it's an unmodified gene that you discover that, by itself does it, you can't have it. These are absolute exclusions to patentable areas. And the thing I would say there is what I think helps the most is if these are absolutely clear. If everybody knows if they're clear, like it will or will not fit through that door, like the shape of a toy or something like that, or those block toys we had as kids, then it's clear. But the problem I would see with this BI, and as you have your 10 years of litigation, is that, well, what is this substantially thing? And then does it fall out because if it's practically or not, doesn't really create a clear door that we know that something's passed through or not. And that essentially just creates these other problems. I think they were trying to kind of say, well, if it's human activity, but not really an invention of some kind, then you can't patent it. But that really, unfortunately, just kicks the can and doesn't really solve this kind of clear, does it get through the door or not problem that have created substantial issues in litigation over the last decade or so.
Yeah, I just want to make one more point. If you look at those exceptions, there are some of them that are subject matter exceptions, and another one is more modality exception, purely in the human mind and all that. That's a modality. It's reasonable to have a modality exception for patent eligibility, but subject matter eligibility requires further justification on policy matters, and I just don't see any explanation in the preamble as to the policies, public policies, that justify the exclusions in these particular subject matter, regardless of the safe harbors, to salvage them. If that safe harbor is good for these particular areas, why wouldn't it be good to any process? Why distinguish those particular areas from any process? So that is my question, really related to the preamble. Missing
That's a great insight.
justification.
That's a great insight, Ron.
I don't have to, one doesn't have to justify modality. Yeah, invention in the human mind, I can, sure. I mean, how are you going to actually show infringement, okay, of a claim? You can't. So there's a practical aspects of modality that are reasonably useful for exclusion, but not subject matter.
Yeah, let me address that, Ron. Since I wrote that language there, a process that is a mental process performed solely in the human mind. I wrote that language for the IPO.
Mm-hmm.
The theory behind that is that was when this mental steps doctrine first evolved in the early 1930s. It was to exclude from patents inventions which required human judgment, arbitrary human judgment. It wasn't that you couldn't have mental processes per se. It was a lack of definition. Sort of like I say, an infringement question. There were patents granted in the 30s and the 40s in which decisions had to be made, and they were mental steps. And you had cases written by the great jurists Rich and others during that in the 50s and in the 60s and the 70s, saying there's no exclusion per se for this. But in order to address these questions of infringement. If the idea is, if the invention as described, as disclosed, if the intent of the inventor was you do this solely in your head, that was excluded. Whereas the Supreme Court said, and the Federal Circuit said, if you, so it went from normative that the invention should be, or is intended to be this way in the mind, as to if it could be, the famous pen and pencil test, the paper and pencil test. If it could be done that way, that became sufficient. And I have a long article on this shift in the law from the positive to the, or from the descriptive to the positive stance on this. But that was the thinking by there. And again, it was more of a, let's give the other side something to say, oh, okay, we're happy with that. I agree with Rob's comment here, criticizing my language here. Well, I don't agree that's not useful. There's lots of things you do in your mind that are useful. I teach you long division in your head. That's pretty darn useful. So I don't agree that it's not useful there. But
only when you apply it, only when you apply the result, then it's useful.
And the process itself is useful. The process of how to do long division is a process. But we're going to get into some theory here. And
let's hone in more on the legislation. Let's hone in more on the meaning of this legislation. We're going to run out of time. So let's go BI. Everything falls into that in one way or another. And then substantially, who knows what that means? Is it substantially technical? Or is it substantially in an economic category? I think that there's going to be a lot of litigation around that. And I think that's what the panelists have said at this point. So let's move on to the second part, which is what they call the savings clause, and how does that work?
Well, I think the veneer of it is that it's codifying existing law, mainly in what we call Alice Step 2, where if you've got an invention in the application, I think that's the verbiage from the Deere case, or under Alice, if you have something, quote unquote, something more. I love this precise, judicial pronouncement. If you have something more than the abstract idea, then it's eligible for patenting. So I think that I think that was their good faith attempt. They're just trying to take the existing law and put it into the format of a congressional enactment.
Let me frame a question here. Let me frame a question so that I can get to the point. I'm going to read this thing here. The process described in Claim 1I shall not be excluded from eligibility, because it already has been. Now it shall not be, for a patent if the process cannot practically be performed without the use of a machine or manufacturer. In the case of artificial intelligence is math. It's statistics applied to large data sets to come to conclusions. A lot of these equations are very simple equations that repeat themselves often. When a court looks at the claims, which is, I believe, how they're going to look at this, how are they going to determine that a mathematical equation cannot practically be performed without the use of a machine or manufacturer? And if the courts can't come to that conclusion, will artificial intelligence be patent eligible under this clause?
Right. Paul, I think you're missing one step. That means, if you read it that way, that means that it's not eligible if it can be performed without a machine or a manufacturer. In other words, all the defendant has to show that it can be. It doesn't mean that you disclose it that way. It doesn't mean that your disclosure doesn't have a machine or manufacturer to perform it, but he can come and say, but it can be performed without it. Here it is. I'm looking at the limitations of the claim and I can do it without a machine. Yeah, it may take me 10 minutes and you can do it in 10 milliseconds with a machine, but it can be performed. Nobody said that it can't. Nobody said that it has to be less than 10 minutes. So the problem is the definition of practical is a big gaping hole. That is the problem. And so you're right. You're right.
I'd like to expand on Ron's analysis here, because it goes to the very, very heart of this problem. First of all, we're all talking about courts and what courts are going to do and whatnot, and we're worried about whether judges are going to make this ruling. Forget all that. Forget all that. We're talking with inventors here. There has been no patent invalidated that first wasn't issued by the USPTO. So when Judge Michel says there will be less of these 101 motions, he's right. Because sports fans, there will be less patents. And why will there be less patents? Because you're going to have a harder time getting through the patent office with these exceptions. Let me tell you how this plays out. After Alice, the patent office came up with their examination guidelines. They codified Alice. They came up with this complex flow chart of a two-step and all these steps. And is it excluded? Is it an abstract idea, mental step? And the examiner would go down this list and say, this is an abstract idea, rejected. And now you had to come back through your patent attorney and say, no, 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 it's not an abstract idea. And you had all these lengthy arguments. And the examiner would say, nope, you're wrong. And the rejections for 101 skyrocketed. I had cases and cases and clients who gave up. We got over the prior art. Prior art was easy. We'd go back and forth 3, 4, 5 times with the examiner on 101. Now, my big clients, big tech clients, no problem. They could pay for it. My small clients could not. They gave in. So as an inventor, your obligation is to come back and respond to the patent office. And now you have to say, no, examiner, you're wrong. The process cannot be done without a computer. Now, you can't just argue that to the examiner. You just can't write a letter and say, examiner, you're wrong. What you have to do will be to provide evidence, and what we call a 132 declaration. That's essentially a declaration from somebody, and it can't be the inventor because the examiners go, you're the inventor, you're biased. I need somebody else. So now you have to pay an expert. Well, most experts are $200, $500 an hour. A declaration is 20 to 30 hours. Okay, so $4,000 to $10,000 to get your expert declaration to say this cannot be done without a computer. Do you have that money? Do you have the money to do it twice or more? So what is going to happen is that examiners will look at this list, and before they only had to work with 3 or 4, right? Mathematical, method doing business, yada, yada. Now they go, oh, that's artistic. That's cultural. Animation, that's artistic. Social network, that's social. You do micro loan processing, that's financial. Every one of these things will become in its own massive category. And so what gets through, you won't even get to court because the odds of getting a patent now will just go down and the cost will go up. And the only people who can play the game are the people who can fund, unfortunately, guys like myself who can fight the fight. But that is what is going to happen.
These same arguments will play out, I'm assuming, you can tell me if I'm wrong, in court on the
Absolutely.
same basic stuff. So
yeah, because once you get through,
let me finish.
Once you get through, the lawyers, because remember, I get paid to beat patent examiners and I win. Okay. The patent is a government employee. Now you go to court, now you've got real lawyers who are getting paid a lot of money and they will make these arguments one more time. And now I'm going to pick up Ron's thread.
Robert, let me get this question in because there's been several questions from the audience about the retroactivity of this. And this goes into the retroactivity of this. If you have claims that are already written, you may not survive a challenge under this because there are 1,000 new arguments that are going to go against your claim. So there is no retroactivity in this. It is retroactive in effect because when you go to court, you're going to be subject to the new arguments under the new thing, I assume.
Yes, this will apply. But I want to elaborate Ron's argument because it was extremely insightful. It was extremely insightful. Okay, can you do this without a computer? And Ron gave the answer, yes, you can. And here's how, let's elaborate that answer. And I think this is the killer answer that every good defense attorney will go. He will say this, or she will say this, Your Honor, of course this can be done. This is a financial method. Well, 50 or 60 years ago, every financial method was done on paper. You went to the bank, you filled out a deposit slip, you handed it to the clerk, they recorded in a book, so on and so forth. Everything 50, 60, 70 years ago was done on paper. It was slow, but it was done. It worked. The statute doesn't say anything about commercially successful. That doesn't matter. It's only going to be practical. And if it was practical then, if it could have been done 50, 60 years ago, it would have been ineligible then. And it cannot become ineligible now. If it was ineligible in the past, the law would make it ineligible today. It has to be that way. And if you as a plaintiff say, well, consumers wouldn't buy it, it wouldn't be fast enough. It wouldn't sell. I can't run a business that way. The response is, the law doesn't say anything about commercial
Okay.
success.
Let's
It
hear
only
from,
says can it be done.
let's hear from Philip Mann and Rudy. We haven't heard much from them. I'd like to hear their opinions too.
Oh, okay, well, thank you. I'm looking at this more from a 30,000-foot level, and we're sort of getting down into the minutiae. I'm looking at what I think the big practical effect of this is, and it seems to me to be very similar to the America Invents Act. It sounds very good and sounds very patriotic and everything, but really had the effect of making it very, very difficult for individuals and smaller businesses to get meaningful patent protection. What strikes me here is the exception for biotech. You know, it says that you can't patent an unmodified gene, but then they turn around and say you can do it if it's modified. They define what modified is. See here, what's so again, that seems to be benefiting big biotech. And as Rob Greenspoon pointed out, maybe with Robert Sachs, the issues here concerning whether it's practical to do something without a computer or machine, that's going to create all sorts of factual issues that will need to be addressed at the patent office, will require the Rule 132 declarations and so forth. But big picture is individual inventors, small businesses can't afford that. Big tech can. So yeah, so when I looked at this, I didn't get so much into the minutiae of the words and so forth. What impresses me unfavorably about this act is I don't think it really does anything meaningful for inventors and small businesses. You know, it sounds good on paper, it sounds good with the intent, but when you really analyze it, it doesn't really seem to deliver what it intends to or what it purports to. So I don't know if anyone else sees it that way, but that's my impression of looking at this thing in a big picture way.
What do you see, Rudy?
Yeah, so I guess I would say I think that I agree with what you're saying there, is that to me, I think people's hearts are potentially in the right place to solve the problem. But as I see the problem, it's let's know what is a patent or not. And you see that language about, that it substantially does this broad category of things. And then to fall out of that, it's got to practically not do these other things. To me, those are very subjective tests and require potentially a lot of analysis, in terms of practical to whom, when, I think are some things we've talked about how that would all play out. And it's just the kind of thing where that's two people might have, kind of very different opinions on that, even if they're trying to reach it, which provides, in a sense, no real certainty about whether something is in fact eligible or not. And again, this is, I think, as the slide said, like, who gets through the door at all? There are all these other elaborate tests in the patent system that have been developed for centuries about, whether something is new or novel, whether it solves these problems. It's still got to get through all of these doors. This is just about at that high level. Can this even be something that's patented? And to me, that should be an area where we should be able to make very clear lines and let things either in or out that door, and then let the rest of the patent system, which has been developed very clearly, solve those fine-grained problems. We don't need to solve them here, at least I would say. But the other point I would say is that even if we do want to solve them here, this doesn't clearly do that. It creates a sort of test that somebody sort of knows it if they see it, like what is practical. People are going to have different opinions on that. And I see that as creating, again, as a litigator, just fights about that. You're still basically, to me, we always have these fights. I looked at it, there's something like 2,100 of these motions have been filed all, in the past on 101. And I don't see that necessarily going down with these challenges. So I like, in a sense, the idea of trying to solve the problem. I just see this as kind of creating a new set of fights instead of really solving them, unfortunately.
Yeah, exactly. And argument I've made to the Federal Circuit unsuccessfully on more than one occasion is a lot of these issues really should be addressed on 102 or 103. I mean, if something exists in nature, it wasn't created. It's not novel, that sort of thing. I don't even know why we're spending, well, I have some suspicions why we're doing this, but officially why there's so much emphasis on 101, where it seems that sections 102 and 103 would take care of old things that already exist or obvious variations. Again, doing it on a computer, to borrow that language, is already old. So if somebody were actually to write a claim that said do it on a computer, why not shoot that down as everybody already knows that? So I sort of view this as is a problem that really shouldn't exist in the first place.
Let's hear it. Greenspoon, what do you got to say?
Sure. I just want to make one quick observation about this final slide here. If you look at up at the top, capital B, this is the savings clause for pharma. And it says, okay, something can be natural and that's presumptively ineligible, like a gene is ineligible. But we get to B, unless it's otherwise employed in a useful invention or discovery. I mean, pharma gets a real savings clause there. I mean, that truly does. That overrules the Funk Brothers decision from the Supreme Court in the 1940s. Funk Brothers should have been held overruled by the Patent Act of 1952, but it wasn't. It's still good law. But Funk Brothers was, basically two naturally occurring substances were mixed. They were put into a giant sack, and you sold the sack of the two mixed substances, and that was useful for farmers. It wasn't exactly a fertilizer, but it was some kind of chemical useful for agriculture, or a combination of chemicals. And that was.
But it's also, but it's also a positive statement. All you have to do that it can be done, and that's a positive statement. You don't have to prove a negative, as opposed to the other savings clause. So that's another distinction.
Right. So I'll let me come out of my rabbit hole about Funk Brothers and just say, farmer gets a real savings clause. So why don't we give everybody a real savings clause? And go back to my first slide, where I've actually proposed the legislation right there in the gray text, in the annotation.
Right, and that's a positive way to do it, rather than a negative safe harbor.
Yeah, and for everybody attending, because a lot of people who are attending this Zoom call are not attorneys, you're inventors, and this is like stuff that you'd rather be inventing than having to go through all this. But the effort here is to head off unintended consequences, and of course, very often unintended what is unintended to perhaps what the bill was intended for, very often appear to be intended by those who vested interest, who actually benefit from how things change once the bill gets passed. So our effort is to really figure out what can be done to head off these unintended consequences and to do something that actually helps the little guy and the startup, because that is who I'm convinced the patent system was really designed for.
I think
So
on the intentions, there's a burden still here for the sponsors and proponents of this bill to clarify their intentions. I don't see any unintended consequences. To me, it looks like they're intending to make it really confusing especially for inventors and under-resourced patent owners. And their intention says in the findings in the section 2 that they intend to prohibit patents on economic, business, financial, cultural, artistic, social. So do we take them? I mean, they're speaking out of both sides of their mouth. So I think the burden is on the sponsors and the advocates for this bill to speak clearly. This is well, don't put out a bill like this that says one thing in the findings and another thing that no one can understand and have lots of questions about in the actual substantive part of the bill.
But Josh, the burden on them is to explain why these are excluded. Forget about the savings clause. Why? What is the public policy to exclude those?
Right. I don't know what their intent is with this bill. It's what are you trying to do? Are you trying to get rid of dance moves and marriage proposals? I don't believe you. What are you really trying to do with this bill?
Well, they told you what it is. The point is they have to articulate the public policy as to why. Why should those subject matter be excluded? What's the public policy to exclude them? I think it's very clear they want to exclude them. It's very clear. Yeah, they give us a savings clause, but there is an intent to exclude them. What's missing is the explanation of why those particular subject matter are excluded. Give us a public policy reason. Somebody's being hurt, somebody's doing business, can't do it because of patents. Give us a reason why those are excluded. That's what's missing.
Or give us examples, even better. If you have reasons, you must have data to support your theory. If you have a theory that these are bad, then you better have data to support your theory and show me patents that were cultural, that somehow hurt somebody, that limited competition. Remember, we're talking about business. We're talking about competition. We don't patent things for glory. I mean, if you do, Go get your paper patent, have fun with that, pay your lawyer, and pay the USPTO thousands of dollars in maintenance fees. We do this because people make investments to monetize those investments over time. So, are you going to patent a cultural thing like what? We can make up I can make up stuff all day long. That's what I get paid to do. So yeah, what evidence is there that is a problem that they should be excluded?
But the answer, and I'm reading some of the comments, and for Judge Michel and others, the answer is we're not trying. They're telling us they're not trying to ban patents on cultural inventions. So there's double speak. Like we ask, why are you trying to get rid of patents on business methods, financial methods? And they come back and say, we're not. That's not what we're trying to do here.
Well, that's what you just did do.
Yeah.
I just gave you. I can run. Any of us can run the argument of exactly how this is what will happen. A good defense attorney will say, this is an artistic invention. It's computer animation for hair. It's a better way of manufacturing a paintbrush or applying a paint color or whatnot. Any good patent attorney, any good defense attorney can do it. And a judge is going to go, yeah, you guys are smarter than I am. I'll buy it.
Josh, I think the way to see that the intent is to exclude them is to say, look, if your savings clause is saving those inventions, the important part of those inventions, why do you even have these exclusions? Why don't you have the savings clause to any process? In other words, don't make any process patentable unless it cannot be done without a computer and machine. Why single out those particular areas, economic and all that, for the savings clause? Why not use the saving clause across the board? It saves everything, right? It should. Well, why single out those categories and only save those?
I want to wrap up this particular thing, and I think that the panel agrees there are risks in the first part of the test, which is they fall into a category. Nobody knows what those categories are. It basically encompasses everything and makes it ineligible to start. Then there are risks in the word practically. What does practically mean? And having to prove a double negative, and that these risks may be substantial. They may take 10 years to clear up. We may be in the same position for the next 10 years, and we may end in that position. My view of a court is that they see two things. They see a patent holder with an exclusive right and an infringer with a product on the market. And they typically tend to fine for commerce, and over time, I think this will be bad. But there's another part of this that I'm wondering about, because I'm not a lawyer, but it seems awfully strange to me that we are creating a statutory authorization to challenge a patent under 101 where there is none now. I know that the courts have case law that says there is, but we're creating a statutory challenge. Now, no other country in the world has 101. What are the effects of creating the statutory challenge?
So I guess I'd step in there and say, as you say, Paul, their kind of case law is essentially effectively a legal 101 challenge. And I think, as other commentators have noted, this is essentially probably codifying that. What I guess I would have a question is, if we're actually making this a statute, why not make this a challenge to validity like all the rest of all the challenges? Why does it need to be an issue of law rather than just a finding normally like other validity questions?
Yeah, particularly.
Can I want to provide this data so all the panelists can see just real quick.
Yeah, I just want to make a comment on the previous, particularly when there is a specific provision that allows discovery on factual issues related to eligibility, admitting that it's not just a matter of law. And that is another question. Why do you?
Ron, I would completely agree with that. As also, I see that as, a lot of these questions about, again, whether something is substantially, within those areas, and whether it's practically or very intense, what I would call from a litigation perspective, factual questions, very factual, and the kinds of things that require a lot of what would be like expert analysis and those sorts of issues. And so therefore, to me, at least I would see them more along the lines of these other kind of factual questions rather than a sort of strict legal question. But I think that comes back, at least in my mind, to the problem of the lack of certainty that the statute provides about what sort of gets through the door to be a patent or not.
Can I jump in on this just to help give a little data here? Can everyone see the data I have up here from an article I wrote a couple years ago?
Yes.
Yeah,
Okay, so this goes to your point. Before Alice, the notion of a 101 motion of her 12b6 was weird. It was unusual. It was rare. Okay, and you can see before Alice, there was about 90 of them, historically. After Alice, there was 1,000% increase, because now it became malpractice if you didn't file a 12b6 motion. That's what happened. So you can see it went from 100 to 800 in just a couple of years. And the number of patents that were invalidated increased 900%. So you're right. This will codify Section 101 motions, and it broadens it because now we talk about discovery. Well, you're litigators. How much does discovery cost? Okay. Before on 12b6, at least you could argue it on the paper. Now you're going to have expert witnesses, you have expert reports, you have depositions. So now a 101 motion, which was generally cheap to argue, more or less $100,000, and cheap to defend, another $100,000. Now it's $300,000. So good luck if you're a solo inventor and you're going up against big tech. You're done.
and imagine the concept, the concept that the judges have discretion to do a lot of things under Rule 12b6, and they can do that and allow discovery and so on. But why codify a specific provision for discovery on eligibility, which is patentability, really, where there's a presumption of validity? On the other side, there's no presumption of non-infringement, and yet that discovery is going to be delayed years before you can even do. Discovery is something that's done mutual. There's a process of both sides are having the threat point of discovery, and they're involved in making investments in discoveries, and they both get ahead in their particular case with discovery. Here, we're stopping the patent holder. We're just dealing with something that is now presumed to be valid, and yet we're opening it up to discovery, holding everything up.
Yeah, I would agree with that, like a little bit in the sense of just to put a perspective on this. I looked, and since about 2015, there have been about 2,100 101 challenges, and they come out at something a little bit less than 40% of those are denied, and that's fairly constant. So, we've spent, the better part of a decade with this, and still it's sort of a coin flip about whether people are able to understand whether something is eligible or not. And so having this as a sort of threshold question as the law provides, you're probably seeing those in every single case. So in this sense
how many of those that you looked at actually didn't just decide it on a matter of law, or said there is a question of fact and therefore I'm denying it, versus an actual allowance for discovery? How many of them were actually had discovery as well?
Yeah, Ron, I didn't pull that out. Sorry, I just pulled that out right before the call to get a general sense, and that, to me, the idea of, something like $210 million worth of these things for the patent system over the last 10 years is using that $100,000 figure just kind of puts a number on it. And so I was just trying to have a general sense of, that this is not some, to use a term, abstract issue, right? This is a concrete cost.
I understand the cost, but I'm just trying to understand procedurally. Procedurally, has the court used this discretion to enable discovery on subject matter issues at the early stage when there was a material question of fact?
And my sense is that varies from litigation, is that generally varies in practice from court to court. Some handle it differently than others.
Mm-hmm.
Paul, why you raised a good point that I think maybe a lot of inventors don't understand here, is that patents are presumed valid. And yet somehow that presumption of validity doesn't apply to eligibility. It's thrown out. And one of the early drafts we had, I wanted to have a provision that said the presumption applies to eligibility. It's not just neutral. The PTO made a finding, and I know there's this whole deference thing in the PTO, and like every other government agency doesn't get deference, whatever, but a presumption should be assumed valid, and valid includes eligible, is what I would argue. So why is it Michel taking that tact, and shouldn't we be looking for that as an additional savings, that starts the game already with our thumb on the scale as opposed to their thumb on the scale. That restores the law.
Yeah, that's the point I was making, that in the balance of litigants' interests and fairness, discovery is a matter of, oh, there are certain facts we don't know, and we can't presume, therefore we're going to allow discovery up front. Well, presumptions, in my mind, undermines or at least limits the justification for discovery on a question that is
I have
presumed to.
one further question on that particular provision on 101 on codifying. So they limit discovery in that. Would it be, I mean, I don't know if it's good or bad to have a challenge on 101 in litigation. If it were a challenged in the same way as 102, 103, and 112, that would go in front of a jury, right? Is it better?
Also, not just in the same way, but at the same time.
Allow that, but not have a limited discovery. I don't know what the answer is here. I'm just throwing this out.
But also at the same time. You should open it up, but also during the same time. So if there's discovery allowed, there should also be discovery on infringement.
Yeah, I would say I think that it would go to the jury, at least in my mind. Again, that doesn't necessarily mean it can't be resolved early in the case, right? So if there is a statute, something like this that says that absolutely can't, you can't have a patent in there, the court under summary judgment could grant that. So it's not necessarily that it has to go there, but if there's some very complex factual question in here, then it would go to the jury. And I think, in a sense, be resolved with all these other issues in the same bucket, which I think could prevent a lot more efficient way to resolve this, because essentially it seems like you're going to end up with something kind of like a bench trial on eligibility is a subset of validity early on, and then the rest of validity later on in the case is sort of two separate proceedings.
Well, if the question is practically implemented, that's experts.
Yes.
That's evidence, that's facts. It's now a question for a jury. And I've made this argument quite a while ago. I published articles saying that you should be able to defeat a section 112b6 with an argument that it's a factual question as to the scope of the claim and all of these other characteristics. So that didn't, it didn't work. Why? Because judges want to clear their dockets. They don't want these patent cases. Only a small handful of judges want to deal with a patent case. It's just too hard. It's too complex. It's just a pain in the ass. So 12b6, what Alice gave them a perfect, just a docket clearing washcloth. They could just wipe away these cases super fast because for them it was judicial economy. Take it to the federal circuit. I don't want to have this here. So you've got this big institutional problem to deal with behind there. Paul, I want to address something that you have talked about. And that is, this kind of question, and Congress seems to agree about global competitiveness and what China's doing. And you said, for example, that China doesn't have this restriction. And some people go, well, just China's a stalking horse. But there's a deeper fundamental issue here is that, again, for our inventors, the question is, can they get investment? Can they monetize? What is the scope of their rights? And if China will allow this and the US doesn't, well, let me tell you how a US inventor gets their patent into China. They first file in the United States, and then you file what's called a PCT application, which gets you the privilege or the right to file internationally, including China. So you've already preserved the right to file in China or Japan or Europe and so forth. If you go to your patent attorney and you hand him your invention disclosure and she says, not so much, it's going to get rejected because it's going to be, an examiner's going to say it's financial or it's cultural or it's this and that. You're going to really struggle to get it through the patent office. It's going to cost you a lot of money to do it. Most inventors are going to give up right there. They're not even going to file to get that patent through. They've already given up the possibility of rights in other countries. So that funnel just squeezes down, and the people who we are trying to support, they have less opportunity from day one to get investment and to monetize their inventions.
There's one more added point to that, Robert, that a lot of times applicants can file a PCT designating the U.S. as a country to be pursued, and the PCT application may be the first case. And then, and if the attorney is saying to them, you're going to have challenges in the US because of this, so okay, let's continue this in other countries.
Yeah,
And then you get a
we do
patent,
that.
and then you get a patent in other countries, and we would not have the investment in this country for any commercialization because there's no protection here. There may be protection in China and other places, but not here. So it will drive away investment, even for
Right, but
American
yeah.
inventors.
Yeah, but you know, that's true. We did that. It's typically more costly. And again, we're talking about solo inventors, small companies. They don't have the sophistication generally or the money to do this, you know, PCT, designated the US, the 18 months, you know, phase, you know, you know what I'm saying?
National phase.
National phase, thank you. You know, so yeah, there are complex strategies, complex, costly. Okay, so yeah, it can be done, but what I'm saying is for most people, most inventors, they'll get told you're going to have a hard time. It's going to cost you a lot of money. Whereas before it would have been, it's silent. There's no question. If you can, I used to say, if you can describe it, I can patent it.
So I want to get on to one last question that I have, and then maybe other people have more questions. I'm certainly not the smartest guy here. They're applying a definition for the word useful. As I understand it, there are already definitions for the word utility. Utility is a different word than useful. How is that going to play out in litigation, and how does this increase the cost? What is there risk here? I don't know. Somebody, Greenspoon, can you give me an answer?
Yeah, I haven't studied it as closely as you have, Paul, but let me share a screen and show you the MPEP section on utility. Can I make that bigger? Let's see. No, that's as big as I can make it. Anyway, yeah, the MPEP has a fairly rigorous, this is the manual of patent examining procedure. This is the sort of rule book that patent examiners are supposed to use. They have a lot on utility. I think very few of us, when we prosecute patents, deal with utility rejections. It's almost unheard of. Utility rejections and the utility requirement also stems from Section 101. It used to be the only meaning or operative effect of Section 101 until the courts got involved with, starting with the Benson case. And it's not that hard to overcome. And I don't think, my first reading of the proposed legislation was we're not really changing the utility requirement, even though we're using the word useful. It's a different word for sure. And maybe I'll be proved wrong on this, but I think we're still gonna have, you know, these same standards that we see in the MPEP can provide a well-defined and particular benefit to the public. And then there's a school of thought, there's definitely a line of case law that says utility is really a non-issue in litigation. If you can prove infringement of a patent claim, then it's intrinsically going to pass the utility requirement. So I don't think it's where I would stomp the ground and bang on the table. I think I would pick other parts of the statute.
I just have one comment on it, and that has to do with the reenactment canon. When a statute is reenacted and slightly different words are used, and here now we have the term in 101 is useful and so on, and now there's a clarification of what useful means. To me, it's not the issue about utility versus useful. It's about the actual definition of a term that is already in the statute, that has been there since 1952, called useful. And now we're introducing definition of useful. And when you read that definition, it's no different than what the courts have found before, what the MPEP identifies as the standard for determining usefulness. And so you could argue, and Judge Michel explained to us that, look, this definition doesn't change the law, okay? In my book, the fact that it shows up under the doctrine of reenactment, it could open an opportunistic way at the PTO, not in court. As Rob said, the fact that the claim is infringed is constructive proof of its utility. Otherwise, it wouldn't be infringed. But in the PTO, before you even get a patent, guidance can start changing. And the justification for changing the guidance at the PTO, in my concern, is that why else would Congress change the law? Explain what utility is. There is, or what useful is. Now we can find in here, in this, a real intent to change the meaning. And there's case law that shows that the reenactment canon applies, and you should really look for the new intent the Congress had. Otherwise, it wouldn't have made the change of the statute. That's why, to me, the preamble is most important, to declare that there is no change and there's no intent to change the law on the issue of usefulness. That would go a long way to make it less problematic, as Rob perceives it.
Well, we're over our time, but I think that we've found a number of issues with this law that probably need some adjustment. We're going to look at that. But I want to go through each of you and have you each kind of summarize where the problems you think are and what you think should be changed. We're going to use this. We have not established as USI, and nobody here is speaking for USI, what our policy is going to be, but we should have that pretty quickly. This call has been informative to that. So if you could, starting with Mr. Sachs and then Rudy, then Robert, then Phil, and then Ron can wrap it up. What you think we don't need to worry about and what you think we should worry about.
Okay, well, I'm going to just return to my key points earlier on. I'm a prosecutor, so I think on behalf of inventors getting through the patent office. I can think about court, but I think about inventors getting through the patent office and the challenges they will face. I have seen what the PTO did with Alice and the preliminary and interim examination guidelines, and how it turned Alice into just a massive patent application rejection machine. And that only had a smaller number of categories. They will take B2 and they will turn it into more and more basis to reject your patent application. The burden will shift to the inventor to try to say, no, it's not cultural, etc. That's going to be hard, okay? Or to prove that it cannot be done without a computer, and that's going to be expensive. And so I think this is bad for inventors because it's going to make it harder for them to get their patents. And even if they get them, we have all the problems we already have talked about in addressing them, about enforcing that in litigation. So that's my major concern. It turns the massive funnel of what should be patentable down to this hypodermic needle that will squeeze out tiny little drops of patented inventions.
Nice visual.
So I guess I would say, I think this is, I mean, I appreciate the effort of the senators here, and I think it's definitely an area that needs to be worked on. I think, my perspective would just be, I think that there should be corrections or tweaks or amendments or whatever it's called that make it more clear. I would see the problem here is that 101, I don't think is useful to try and make fine-grained choices about what a patent should or should not be. It's like bright lines, and if you cross those bright lines, you get obliterated from orbit no matter what. And so the problem here is that we have these sort of tests that are going to be very fact intensive and vague, and nobody's going to necessarily know whether they've got a patent or not till they get into litigation, and then maybe even then till it gets appealed or who knows what. And so I think the best way to be useful here is to create bright lines that are clear about whether something is or is not a patent. And if there's some other issue they want, push that into some other part of the 102, 103 area, but make the door clear. Like, whether or not, like, is it a mathematical formula? Okay, we can know that. Is it a gene? Okay, we can know that, but this sort of more fine-grained thing, like, is it substantially this, and then is it practically that? I don't think provides the clear certainty that, at least as I read the preamble of this, the proponents were trying to eliminate. I think it is since going to create a lot more fights and kind of create them more everywhere. And the only thing I would say other than that is, I think if that's done, then maybe it can be a legal question because it should be so clear. But fundamentally, I would push all that validity into just all of the validity questions of fact and remove it as a question of law and solve that issue that way as well. But otherwise, that's basically what I have to say.
They say the perfect is the enemy of the good, and
Yeah.
we get that. everybody gets that. You know, you don't want to block legislation if it's going to have some beneficial outcome for a lot of people. But the bad is the enemy of the good too. We shouldn't, forget that. The catastrophic is the enemy of the good, the perfect, and the neutral. So we just need to keep all this in mind and be very careful about supporting any legislation that makes things even worse. My personal belief, I've been very upfront about this. This is Rob Greenspoon talking. This is not US Inventor. I think we should just eliminate the judicial exceptions. Going back to the Benson case, where things really started to balloon in this area, the early 1970s, the motivation behind the Benson case was that the justices on the US Supreme Court were scared to death about software. And they actually had a United States Patent and Trademark Office, very different from today, who affirmatively tried to get software declared unpatentable. For 5 years, there was a campaign of basically lobbying to the Supreme Court and to Congress to make sure that the Patent Office was never going to have to be responsible for examining a software patent. Well, believe it or not, the Supreme Court, Benson was actually a mixed decision, 1971, I think. They said software could maybe be patentable, but we're going to call this particular mathematically focused piece of software, we're going to call that ineligible, and then everything just came out of that. So, things have changed. The original trigger that got us down this road doesn't exist anymore. The Patent Office is perfectly comfortable examining software inventions. So why don't we go back to first principles and just ask the question, do we even need this judicial exception business that started with the Benson case, when the whole rationale behind the Supreme Court starting us down this path doesn't exist anymore?
Okay, I'm approaching this from the perspective of somebody who tries to represent smaller companies and individuals against much larger ones, and has to do it with a comparatively shoestring budget. So I am admittedly biased on this, and my bias is in favor of the individual inventors and the smaller companies against large companies and so forth. I view this, I think this is, the heart may be in the right place, and frankly, I'm not sure about that, but I think it's nice that this bill is at least attempting to remedy a problem that everybody knows exists and that we've been living with for coming up on 10 years almost with Alice, and something has to be done. So as I said at first, maybe this is a shot across the bow indicating to the courts that you better figure this out, because if you don't fix this, we're going to fix it for you. And I think that's good. But when we got into the specifics of it, and particularly the ones that Rob Greenspoon has pointed out, this is a litigator's nightmare or dream come true, depending on which side you're on, whether your client can afford this. This is going to create just ample opportunities for more litigation before we even get out of the starting gate. You know, we're, as I said, many of the cases we look at, we don't even take because there's an obvious problem, an Alice problem, and we're likely to at least face an Alice challenge, if not get defeated on it. And even if you succeed in that, you still have the problem of the IPRs. You know, you've got that headache with the American Invents Act. And I find this, even if we win with the jury, it's likely to be taken away at the federal circuit. So there are just so many hoops you have to jump through to successfully litigate a patent. This just looks like one more that they're putting up there. And it's anyone's guess what sort of issues we're going to see, but it's more of a gut feeling than a sound analysis. I don't think this is helpful for small inventors and small companies. And again, that's speaking for myself, not for anyone else. Thank you.
Yeah. So I actually believe that it's not just their heart in the right place. I think their mind is also in the right place. It is certainly an effort which is unprecedented to try to solve a problem. Those who proposed this legislation have worked probably 2 years or more to get where they are now. So they should be commended for this effort. We do see a problem, though, in some of these areas, and to me, I would not argue that this bill should be rejected. It should be improved, and And ironically, the improvement that could be most effective are actually in the preamble. For example, if you set out the criteria as to the policy as to why, substantial economic, financial, business, social, cultural, artistic inventions should be limited in a certain way. If you make that in the preamble explaining it, maybe you will help narrow and cabin these categories in a way that is better understood. And second, if you also define in the statute the term practically, that could help as well. And then on the other two areas, the uncertainty about usefulness and the litigation discovery of limited discovery, again, the preamble explaining this and cabining the scope of these amendments could be very, very helpful. So I think improvements are a need here rather than just rejection.
I'd like to say now, and this is not the position of U.S. Inventor, this is just me personally talking. America has been discouraging innovation for 15 years or so through the various Supreme Court decisions and American Invents Act, while China has recently been encouraging innovation. And it's critically important to our country that we encourage innovation, especially from the small entities that have been so important to our past and are so important for our future. And it's our intent with this Zoom meeting and all the efforts we have underway right now to determine what can be done to ensure that this legislation does not continue to discourage innovation, especially from small entities. So we're going to be looking very closely at this. We're going to be talking to all our members, talking to very intelligent people who are in the trenches, and we'll be communicating with all of our membership, and we'll be talking with you guys, and we will have a position fairly soon, I think. But the key is the bill has to be it has to be good for the country, and it has to be good for small entity inventors who are such a key part of our country. So I want to thank everybody, especially all of our panelists here, for attending and being a part of this effort. And thank you for being a part of this effort, everybody out there who's attending. And we'll see you next time. Thank you.